Good afternoon to everybody, and welcome back to the first webinar from the education team in Mason, Hayes Curran in this new school year. And a special welcome to anybody who is joining our webinar for the first time. I hope you all had a good break during the summer and that you're all fit and well for the year ahead. Now, today's webinar, for those of you who joined previous webinars, has a slightly different focus. And by way of background, let me explain that a number of principals and board chairs as well said to us over the summer, it would be great if we could give the schools some content which could be shared with some staff members, including some of the issues that we've covered in previous webinars. So I make no apology today if some of you, go through this webinar and feel that, you've already heard some of this advice before, because the ultimate audience for even some of today's webinar is your staff. Now, you'll know and decide how best to share some of today's content with your staff members and how relevant some of it will be. So the first slide we put up there is a light-hearted slide. This I picked out as David Ruddy's staff room when he was a principal at the beginning of the school year before he went the legal route. So hopefully your staff room isn't quite like that. So let's kick off. Paul, over to you.
Thanks, Ian, and good afternoon, everybody. And I suppose to the forefront of everybody's mind at the moment is still COVID-19 and the fact that it's still with us and we still have to deal with it for the foreseeable future, even though there does seem to be some light at the end of the tunnel. And the department has issued relatively recently an updated circular to cover all of the arrangements in relation to return to school, as noted there, 42 of 2021. And they've also issued a guidance letter, and that has gone out to everybody in recent weeks. What they've also done is sent out a template COVID-19 response plan, and that went out sometime, I think, in the middle of August. I would assume that all schools have worked through that at this stage and kind of set out based on that template what their plan is. It's never too late if you haven't concluded it yet, but it is important that people are aware that that plan should be finalized and ready for your board of management to approve at their first meeting of the year, which will probably take place within the next couple of weeks. And a lot of what is set out in the circular will be very familiar to all of you from what took place last year. And I think the approach could best be summed up in a headline I saw recently where it said, look, a lot of things worked last year, so we're going to continue to do those. And that's the case. So we will continue with the infection prevention and control measures that were in place during the previous school year. Those will be continued. There will be the requirement for return to work forms, so either new ones or a confirmation of what was in the last one submitted. A lot of this and a lot of the framework around return to school is about managing risk. And I think we have said on previous webinars that there's no such thing as a zero risk environment in relation to this within a school. So what you have to do is try and minimize the risk and manage it properly. And one of the tools to do that is risk assessments. And those will have been done in the past, and there may be a requirement for new ones for the start of the school year, or to revisit those previously done and to ensure that they're still current and up to date. Ventilation will also be a significant part of the management of the school environment. And there was guidance issued on that back at the end of May. And one of the other kind of new elements to that is the carbon dioxide monitors, which are going to be issued, I understand, sometime in the middle of this month. Of course, one of the new factors that we're now taking into account as we return to school is the presence of vaccinated people within our community, within the workforce. So that has changed the landscape dramatically in terms of how things are managed. So, there's been a lot of discussion about this, but, as in schools, as with other workplaces, there's no legal obligation on members of staff to disclose their vaccination status, even though the vast majority of people may be quite comfortable in doing that. But there are certain exceptions to that. So, for example, where a member of staff may be a close contact of a person who's tested positive for COVID-19, the management of them as a close contact, their vaccination status, or as it's termed in the circular, the significant vaccine protection status, that is a factor in how they are managed as a close contact of a person who's tested positive. So that will be one where that information is relevant. Another situation where that will be relevant is where a person has to go for an occupational health assessment, where they feel they may be within a high risk or a very high risk category. And again, your vaccination status will become a factor in making determinations around those categories of risk, and high risk and very high risk. So that will be one other area where you'll have to disclose at that point. And another area that has been discussed quite widely within the last couple of weeks is the situation in relation to pregnant members of staff. And as you'll see from the first line in our slide there, up until this morning, we had designed our slide based on the public health advice as it stood at the time, which was that pregnant members of staff could avail of the vaccine from 14 weeks gestation on, and that was the recommendation of public health. That has, it would appear, changed as of this morning. They're now the NIAC has now come out and said that it is perfectly safe for pregnant people to get the vaccine at any stage within the pregnancy in consultation with their own obstetrician. So that is something to be aware of. And then the provisions in relation to pregnant staff members are set out within the circular. So where you're not vaccinated, it's safe to return unless you have an underlying condition based on medical advice, either from occupational health or from your own obstetrician. After, at the moment anyway, after 14 weeks of gestation, you may have to go for an occupational health assessment. Again, your vaccine status will be a factor in that, in terms of where you lie on the normal risk, high risk, very high risk categories in relation to your pregnancy, and how that impacts your attendance then at the workplace. There are special considerations then for special education settings, obviously because of the slight difference involved there. And there are two streams to that, special classes within mainstream schools and then special schools themselves. So there are a number of criteria set out in the circular, where you're at the moment, where you're more than 14 weeks gestation, where you're in a high risk category, where you have more than 3 employees in the room working together, and where the social distancing between those employees rather than between members of staff and students. So where the social distancing between members of staff is not possible on a consistent basis. Well, then if you have all of those 4 factors together, then there may be a requirement to look at an alternative method of working for that particular member of staff. And within a mainstream setting, a special class, that may be reassignment to another class. Within a special school, that may be reassignment if possible, or if not, working from home. So I think the thing to take away from it is it's quite detailed. There's a lot set out in the circular in terms of how the system works with regard to attendance at work for various categories of staff. So I think it's important that people familiarize themselves with that and then work with their school management in order to determine what the best solution is for them in their particular situation.
Paul, thanks for those updates, and we'll come back to you in a couple of moments. Our slide header here says you don't have to be a lawyer to be a teacher, but increasingly compliance has crept into schools. And indeed, Ian Henry, our head of education, who has spent a lifetime representing schools, would say that schools have changed beyond all recognition in relation to the compliance demands. So we're going to speak somewhat today indirectly about your duty as an employee of the Board of Management. And what you'll find, as Ian and Edel and Paul reference different areas, they're going to refer to the school policy. And it's really important that as employees, we adhere to the school policy, which is ratified by the Board of Management. And the board, of course, indemnifies us if as professionals we make mistakes. So this is why it's so important that we stick to these policies. We're going to also speak about the onerous duty of care that we have to pupils, because no matter how good your school is, parents want their children to be safe. And we'll also speak in particular about child protection. Now, just to get things rolling in relation to yourselves, we're going to run an online poll, and I'd encourage you all to participate in it. It's anonymous. And here we have a situation where a teacher is rostered to supervise on yard. On her way to the yard, she has to deal with an incidental issue, an upset student. However, in her absence, a fight breaks out in the area that she was due to supervise, and the student is injured. So we're asking you for a yes or no answer here, just to prod you more than anything else. Is Mary negligent? So if you could vote no, that would be great, please. And when we take that scenario, we'll move on to a second one.
It's worth saying just on that, David, that, you know, we find that some of these situations are tricky for teachers and also for lawyers, because it's not always a simple yes or no answer. And that's why I suspect that, you know, there may be divided opinion, and we can talk about the answers to that in a couple of minutes.
So Aoife, we're just wondering, has the voting started here or that? I'll go on to the second question, and we'll come back to the voting then in a minute if you can. The second one is John feeling unwell in the classroom. He has to go to the bathroom, leaves the class unattended for a couple of minutes, leaving an SNA in charge. Unfortunately, while he's out, a student takes out some sort of an elastic a band with a missile and injures the child. So the question is John negligent or not? So I don't think the voting system is working at the moment here, so we can come back to it. We can go back. Oh, sorry, it is actually. That's just the results we're waiting for. Wow, this is very evenly divided.
This is down a split decision, David. Down to
I wouldn't have thought that. Any reaction from the team before we move on? Are you? Yeah. Well, that indicates the complexity of negligence. But the good news is I'm going to call in Edel, and she's going to give us all the answers in her next piece here, Edel. So
thanks, David. Speaking of complex issues.
No pressure on you. So we move on to negligence, Edel.
Yes. And, you know, without sounding like one of my lecturers from college on civil wrongs and everything else, we'll just speak about the general principles of negligence. So the general law of negligence provides that a person may be negligent if, number one, they owe a duty of care to the person injured. Number two, they didn't carry out that duty to the legal standard that was required. And number three, that person suffered damage and or an injury as a result of that person's failure to reach the standard of law. So that's kind of the three-step consideration in terms of negligence and the law of negligence. There's no question but that the duty of care is owed by teachers to students, and the standard that's required and indeed of SNAs to students. And there's no question but that the standard that's required in terms of determining the standard that they should reach is that of the reasonably careful parent test. So that's the measure, if you like, against which their actions or inactions will be gauged against in determining whether or not they have failed to reach the standard of the duty of care on their part. So maybe if we move to the next slide, in terms of negligence and what I suppose flows on from a negligent act, you know, the question that is asked is by teachers, by SNAs, what happens if I'm negligent? And going back to one or those two scenarios that were outlined there, David, you know, teacher says, okay, this incident has happened. You know, what liability, if anything, do I carry in respect of that act or that injury that was sustained by a person? So effectively, it's the board of management as either the teacher or the SNA's employer who is liable for the acts of its employees. So who employs you? It is the board of management is the employer. And there is a complex relationship. And I know that it's a whole other webinar. The whole issue of the DES is that that's the paymaster. Does it make the rules? But it is the board of management who is the employer. And as such, the board of management is vicariously liable for the acts of its employees as conducted in the course of his or her employment. And that brings me neatly on to the next point is this: does board of management insurance or state indemnity always cover me? The board, as you know, is required to have good insurance cover in respect of public liability, the acts of its employees, and any defects or otherwise in the building. So in circumstances where there is a negligent act, and if the employee has carried out that negligent act in the course of his or her employment, then the board of management insurance should cover him or her. Now, I have to qualify that by saying, if, for instance, the employee's acts or omissions couldn't be said under any reasonable review to have been conducted in the course of his or her employment, then that is something that obviously, or not obviously, but may well not be covered. And by that I mean a criminal act, for instance, which would go far outside what would be the duties of employment in which in which that employee works, and therefore would fall outside the remit of liability and cover in respect of that board of management insurance. Also, things to take into consideration would be the board of management's policies and the board of management's policies that they have in respect of certain work practices, for instance. So if you have an employee who is found to be negligent and they have breached a policy that's in place by their employer, then there could be a question mark over whether or not the school's insurance policy will cover them for acts that are carried out contrary to that policy, for instance. It's very much a case of the individual circumstances, and that is, while I'm describing the general principles that apply in respect of negligence, it is very much the lawyer answer of a case-by-case basis, but it's just that every situation is unique, and as such it would have to be considered on its own particular set of facts.
And Edel, we'll then, thanks for that, move on to the question of supervision. And you've put together just a summary of the many questions that comes in to the education team.
Yeah, and the first one actually, David, is one that I was only dealing with today actually on a client call, which is what happens if a student runs out of the classroom. And the client in this instance said to me, this is something that has happened. And, what would you have recommended, or what do you think should have happened in that instance? We are a small 2-teacher school. We don't have the manpower for somebody to run after this child. What are we going to leave, 30 odd students there on their own? I mean, what options would have been available to us in that instance? In that situation, I'd argue that the 2-teacher school has even a greater need to have a plan or protocol in place for this exact situation. And every school, by the way, should have an emergency protocol for different incidents that happen. And no doubt they do have one. But this particular situation is one that should definitely be included in that particular protocol. So again, on each particular facts, I mean, if a student runs out of the classroom, ideally you would be able to call on somebody to cover the class that you are teaching and leave that to try and locate the student. But if that isn't possible, it's very much, what would the reasonable person do in that particular set of circumstances, just to reduce the risks for everybody involved. So, I mean, if it was If it was me in that situation, I mean, it very much depends on what age are the students involved in the particular classroom. Is there somebody in the classroom next door? Can I go to the teacher next door and say, listen, I need to go to this for 5 minutes. So-and-so is missing. Can you keep an ear out for the class? Is that sufficient? It depends on the proximity, let's say, of the classroom. Can this, these are the different factors that have to be taken into play. But what I would urge schools to do is to have their own particular protocol in place for this under the emergency policy or emergency protocols generally, and to even have a practice run of it having happened. What do we do in that situation would be my recommendation.
And to rehearse the scenarios, Edel, you're very strong on that, it seems.
Yeah, I think so. And just to even have the protocol in place, David, and I think rehearsing it out is something that would, I suppose, explore the workability of that, paper plan. There's nothing like it kind of being actually acted out to see if it's actually something that works or is feasible.
Yes, no, well done. And the next two issues that come up, and teachers always ask this about the ratio of teachers to students on the R's. Have you a magic number for us?
Well, when we were looking at this, I mean, I said to you, David, is there an answer to this? And because it's one that I'm asked all the time, and there isn't a specific answer. I mean, it depends on so many circumstances, as in the layout of the yard, the amount of students who are in the yard, the age of the students. On any reasonable review, is it possible that two adults, supervising a particular square footage of ground with X amount of students of X age? I think you just have to have a review of the situation, and again, explore it, consult with staff and think, well, what do we think is an adequate level of supervision here in terms of the supervision? But not only that, I mean, if a school is having incident after incident in the yard rather, that must prompt a review of the level of supervision. To say, you know what, looking at the incident book, there's been X amount of incidents happening. We need to review this. We need to up the level of supervision or take some kind of responsive action, I think, in terms of considering the level of supervision. So again, just to review it, David, would be my advice.
And you're saying the expertise often lies within the school itself. They will know the exact situation, the layout, and the different types of children, the ages, etc.
I think it comes down to, the principal and the teacher's own professional judgment on it. I think they should agree on it as best they can. But that would be my best advice on it, and that they can stand over. Well, why is it that we consider this to be the appropriate level of supervision, and did we review it? And
get the board to sign off on it in the end, just to cover things off. And finally, another easy question for you. Two students fighting on the yard or wherever, and
should I physically intervene to separate two students fighting? Well, I probably shouldn't, given my stature, but any of the rest of you probably would be better. No, but on a serious note, again, it depends if we have, if there's two 6-year-olds that are, involved in some kind of fracas, my chances of successfully separating them, or at least reducing the risk that they pose to each other, is probably greater than if there was two 12-year-olds even. I don't think that there's an onus on anybody to physically intervene to separate two students fighting. I think, and everybody makes a decision on this kind of based on it's kind of a flight or fight reaction, okay, well, you have the response. I think the response is, how do I stop them from doing this? I think I would be calling on an adult or a child who's nearby to get further assistance, to call a third adult or a second adult into the situation to assist. And I think, steps short of physically intervening would be what I would probably lean to. That would be my inclination. And I suppose the question I'd be asking myself is it reasonable that I wouldn't intervene where there's two, 12-year-old boys that are absolutely, killing each other? I think what would I do? I'd shout, I'd call for help, I'd, do my best to try and stop them maybe. But again, it's you'd be gauged against what was reasonable in the circumstances. And I think, again, each individual set of facts there, if it isn't too serious at physical involvement, for instance, I might feel more confident about it. But I think it's a judgment call in that split second.
And rehearsing the scenario, as you said before.
Look, it's not outside the realm of likelihood that this incident could happen. So I think there should be a kind of an agreed protocol again. Well, what do we do in this instance? What's best practice? What are we agreed is probably the best thing to do? Put that into your emergency plan as well.
Thanks, Edel.
David, one principal last year told me that she threw a bucket of water over two students. I don't think that's necessarily recommended practice, but
I think that's legal advice. But
I just put it out there for what it's worth. Yeah.
I think as well, David. I think the theme here that Edel is coming back to is that what is reasonable in the circumstances. These are all things, I think, to a greater or lesser extent, that lend themselves to a risk assessment. They're not unforeseen events. So I think you can do a risk assessment, in the same way you would for a health and safety issue, in which case some of them are and touch on health and safety, but you can do a risk assessment and use that then and the expertise of the leaders within the school that you touched on there to determine what is the appropriate response, and then set that out in a policy, and everybody should know about it. And as Edel says, do a rehearsal.
Absolutely, Paul, and thanks for that. So we're going to move on to another poll here, and this is in relation to Mary, a student. She's confided to her teacher, Una, that she's been assaulted by her mother's boyfriend. And the question is, what should Una do? And you just a single box to tick: respect that confidence, it was given in confidence, or contact Mary's mother, inform the principal DLP, or contact the guards. So I'd ask you, this is a precursor just to our piece on child protection that Ian is going to lead with in a few moments. So if you could vote there, that would be great. And thank you to Aoife behind the scenes there for organising the poll, and we'll have the results as soon as they come to hand. Yes. Oh, well, look at that, 98%. So well done on that. Ian, this is going to make your job and Paul's a little easier, isn't it?
Yeah. Well, hopefully so, David. No split decisions there. Well, child protection. The first thing to say about child protection to all of you principals and teachers is that, schools have traveled a massive road over recent years in the area of child protection, and schools are so much safer as a place for children to attend than they were perhaps decades ago. They're so much safer. And you'll all be familiar, back a good number of years ago, the introduction of what became known as Children First, and the document or the policy. There was then the child protection procedures that we referenced there from 2017. And then, of course, we have the Children First legislation, the Children First Act, which put the Children First protocol, if you like, onto a statutory basis. And the one thing, and before we move on to that next slide, is just to commend that 2017 procedures for primary and post-primary schools to you. It's a really good document, which we consult, if not on a daily basis, on a weekly basis ourselves, when we're trying to support schools with a child protection issue. And just to deal with the legislation that came in, the Children First Act. The Children First Act created a new class of individuals known as mandated persons. And we're often asked by school staff, well, who is encompassed by that term? And there's a definition in the Act. And one of the categories, there's a whole series of categories of different types of professionals who are mandated persons. But in a school's context, The only people who are mandated persons are all teachers in the school who are registered with the Teaching Council. So it's registered teachers. And if you're a mandated person, if you're a teacher, you have two statutory duties. And one, we're going to examine the first one in more detail in a moment, but one is to report any reasonable concerns of harm above a certain threshold to TUSLA. Now, there's a number of those elements which we need to discuss more in a moment. And the other statutory duty is to assist TUSLA with their statutory functions. And we also get asked regularly, well, what about other non-teaching staff, SNAs, school secretaries, caretakers, whatever it is? Well, they are not encompassed within the definition of mandated persons. So they don't have these statutory duties that mandated persons have. But I don't want to pretend that they don't have duties, because every member of a school staff has, a moral duty, if not a legal duty, a moral duty to inform the school principal, usually, of any concerns that they have about risk to any child in the school. So it's not that they don't have duties, but they don't have the statutory duties of mandated persons.
In that clarification between mandated and non-mandated is really important, and I'm glad you've clarified that. Thank you. Paul, Ian talked about reasonable concerns of harm above a certain threshold. You're going to develop this theme, as it were.
Yes. Thanks, David. Yeah. So as Ian said, there are a number of elements there to that obligation that's put on mandated persons, on registered teachers under the Act. And the first piece to look at is the reasonable grounds for concern. So, what constitutes the origin or the genesis of the concern that may turn into the referral to TUSLA. There are four categories which are set out there on the slide, and those are set out in the procedures that we saw on the slide a few minutes ago. Some of them indeed are defined in the legislation itself. But they are set out very clearly in the procedures, both in terms of what they are and in terms of what the kind of indicators or things to watch out for are that might constitute each of those kind of categories of grounds for concern. So I would suggest, as Ian said, he commended the document to everybody, to all teachers to review. I would say, now at the start of the year is a good time to go back and have a look at that, to familiarize yourself with what it says in relation to those various categories of abuse that may give rise to a ground for concern. And then from there, if you observe something that fits within one of those categories, from there, then you move on to where you have reasonable grounds. Because what the Act says is that where where the teacher knows, believes, or has reasonable grounds. Well, it's in a fairly rare circumstances you would absolutely know that something has occurred, unless you had perhaps witnessed it. But the reasonable grounds is the most likely situation where something happens that gives rise to a concern that establishes a reasonable ground. And then moving on from there, in terms of the next kind of piece of that obligation is that there is harm has been caused arising from one of those areas that we looked at in terms of reasonable grounds. So what is the definition of harm? And it's set out in the Act, in the Children First Act, for us. And it's set out as it is there. So assault, ill treatment, or neglect of the child in a manner that seriously affects or is likely to seriously affect the child's health, development, or welfare, or sexual abuse of a child. And then in both those cases, that can be whether caused by a single act, omission or circumstance, or a series or combination or a number of acts, omissions, or circumstances. And I think, and it's important to understand as well that, we'll move on now to talking about, so that's the grounds for concern that harm has occurred. And then the next section of it is the question of whether or not the threshold of harm has been surmounted or reached. And this is often arises, most often arises where a teacher has a concern, either because a student has come and spoken to them or because they've observed something as we saw from the poll, you go to the DLP, who is most often the principal, and the two of you will sit down together and discuss this, and you'll determine whether or not those reasonable grounds exist. You'll determine whether or not you've met the definition of harm and whether or not it's above the defined threshold. And the threshold in the case of the first three that we saw, so neglect, physical abuse, and emotional abuse, is the threshold that has to be crossed is where the child's health, development, or welfare has been or is being seriously affected or is likely to be seriously affected. So that's the threshold that you have to cross. And it's worth pointing out, and as it's kind of differentiated there in the definition of harm within the Act, that threshold that I mentioned there doesn't exist in the same way in relation to sexual abuse. So any form of sexual abuse, by virtue of the nature of it, crosses the threshold of harm. There's no kind of assessment of whether or not the child's health, development, or welfare is likely to be affected. It's if you have a reasonable grounds of concern of harm arising from sexual abuse, your threshold is already met, and it's just important to kind of identify the difference between those two categories. And I think then just moving on to the next slide, the other kind of aspect of this is you do have an obligation as a teacher, as a registered teacher, as a mandated person under the Act. And part of that obligation is you can't report a concern anonymously. In most cases, as we discussed in the previous slide, you will be going to the DLP, and what will happen is you'll have a joint report or joint referral to TUSLA that will be made by the DLP. There are instances where the DLP can avail of, on an informal basis, they can go to TUSLA and get an advisory opinion from TUSLA in relation to a set of circumstances, where it's not a referral, it's just a request for an advisory kind of response. And that can assist in determining whether or not to make a referral. But in the case where you're making a joint referral with the DLP, then your obligation as a mandated person, as a registered teacher, has been met. You don't have to go off and make a separate referral yourself. So your obligation has been met in that instance. There may very rarely arise an occasion whereby you have a difference of opinion with the DLP, where the DLP doesn't feel that a referral has to be made for whatever reason. But you still have an ongoing obligation as a mandated person. So you will have to consider whether or not, despite the DLP's view, you still feel that a referral should be made, because that remains your personal obligation as a mandated person. So, as I said, arises very rarely, but just something to be aware of and to keep in the back of your mind. And as it says there are no criminal sanctions generally on teachers who fail to report under the Children First Act. There are possible administrative sanctions that are laid out there. There is also, bear in mind, the 2012 Act in relation to the reporting of abuse against children and vulnerable adults, which may come into reckoning. But generally speaking, it is a statutory obligation, but there aren't any direct criminal sanctions arising from the failure to observe it. Nevertheless, and certainly in our experience, we understand that teachers take their obligations and their responsibilities as a mandated persons very, very seriously, and as it should be. And you know, they should be aware that there is a lot of documentation there to help them and to guide them in relation to fulfilling that obligation. And also they have the very able assistance of their principal or DLP, who can help them then in terms of their obligation as a mandated person as well.
And Paul, just to add to that, the default position really would be, if in doubt, obviously the DLP will assist and they'll discuss it, but the default position is to seek advice from TUSLA in a situation.
I think if there's any doubt whatsoever, I think, you know, we always say to principals, if you're in any doubt, you should utilize that advisory capacity that's there with TUSLA, and that's what, and they are very responsive in relation to that.
Thanks for that, Paul. We'll come back to you in a moment here. Now we're going to look at the next thing is, and forgive my clicker here, it's gone a bit askew here today. I just want to speak briefly about a secondary reason why we should stick to our procedures, and it's very much secondary. Child protection is the primary one, but is monitoring by the Department of Education. Now, this is not something the department volunteered for. The Ombudsman for Children and TUSLA were very adamant that they would monitor and inspect schools. So there are three levels of monitoring. One, the very basic one you could say would be typically in an incidental inspection, or it's more colloquially known as a drive-by inspection. And there are three compulsory checks there. They're fairly straightforward. Is there a child safeguarding statement on display in the school? Has the school the name of the DLP on that statement? Has it been ratified by the Board of Management? And you're required every year to revisit and re-ratify the plan. And finally, teachers visited will be asked, have they actually read the plan and do they understand their responsibilities? And Ian alluded to those earlier on. The second level has 8 compulsory checks, and that would be more associated with a whole school evaluation, where a school gets a short number of weeks' notice, and there's a layer added to that. They will look for records of Board of Management meetings, and they will inquire as to whether some curricular work has been done in relation to SPHE, Stay Safe, and RSE, and that. And then finally is the forensic inspection. This is the level 3 monitoring, which can take place, the child protection and safeguarding inspection, over 2 full days. It involves 10 main checks with up to 65 sub-checks. It's forensic. And normally what happens is the inspector will visit the school and they'll do an interim report, and then the school gets an opportunity to correct any imbalances, or if you haven't attended to something, and then that's published. So the best way of getting your head around this is actually to go into the department website and look at the number of reports that have been published there, and they will give you some idea of the level of detail that they seek and require. So we're going to move on to another issue that is very topical at the moment with our education team, and I'd also like to pass on our New Year good wishes from Liam Reardon, Catherine Kelly, and Anya Haberlin, from other members of the education team. But Edel, you're going to deal with this, and in fact, I think you have quite a few cases on your desk at the moment, so no better person to talk about it. Over to you.
That's it, David. It's something that comes up, well, certainly this time of year, August, most definitely. It comes up a couple of times per year throughout the course of the academic year for me anyway, and certainly for other members of the team. At the moment, the dispute about the choice of school. So this is one that I'm currently advising on, as you say, in one particular school, whereby the father of the child has enrolled him in the school, and the school has now received an email from the mother in which she states that she's objecting to the child's enrollment in the school, and that, you know, and is stating, look, this child is actually enrolled, my child is actually enrolled in another school, this particular school, and I don't agree to his enrollment in this school. So I'm currently advising in that situation. I mean, my advice in that particular situation is that the school, when it receives an enrollment application under the admissions acts and everything else, you know, should and does enroll child. The form is duly completed by the mother or the father. We don't look for or require 2 signatures from both parents on it. And in circumstances where there is a dispute about the school, like in this situation, I advise the principal of the school to respond to the mother and to say, look, you know, that if there is a dispute about the choice of the school, that is effectively a family law issue that is best dealt with via your solicitors, by yourselves to reach agreement. But, you know, it isn't a matter for the school to decide on. We receive an enrollment, we accepted and offered a place to that student, and that place is there for him. And now the difficulty arises in terms of dealing with issues of parental disputes where the custody or access arrangements are unclear or unknown to the school. And, you know, that gives rise to difficulties whereby if, for instance, a parent comes to collect a child in the school who doesn't have who doesn't have, let's say, access, or there wasn't a parental arrangement in place for that parent to collect. And typically, and it should happen, and it's recommended that parents, separated parents, should make schools aware of what the arrangements are in terms of drop off or pick up. You'll have the primary caregiver being one of the parents, but access arrangements or pickups, and that information should be sought by the school, or should be provided by the parents of the child. It's not that we have to, or a school shouldn't feel that it has to police any agreed access or custody arrangements, but they should certainly be made aware of them. And I suppose turning to the next bullet point in terms of what for me is the starting point in determining or trying to get some view on a parental dispute as it's affecting a school with regard to any issue concerning a child. The first question I'd always ask is, what is the legal status of the parents? And specifically what I mean by that, are they guardians? Are they non-guardians? Are the parents married? Were they married? What information do we have in respect of their guardianship status? And why that's relevant is because in Ireland, if you are a guardian to a child, then you have duties in terms of ensuring that that they're properly cared for and that you maintain them. But also, as a guardian, you have certain say in terms of their religious or secular education, in terms of decisions that might impact on their health, and their health, and that's absolutely relevant, obviously, for a school, because you need to establish, in circumstances where the parents aren't married, are they legal guardians? Because as a legal guardian, there are those rights and duties. So the legislation on the issue of guardianship is the Guardianship of Infants Act 1964 and the Children and Family Relationships Act. Basically, the position is this: there's automatic guardianship in circumstances where you have married couples or civil partners who are cohabiting. Acquired guardianship can happen if parents to a child subsequently get married. So that's acquired, it's automatic, there's no need to apply to adopt or anything like that. In terms of the rights of unmarried fathers, the new legislation, I'll call it new, it's from 2015, meant that unmarried fathers who had previously up to that point under the 64 Act not have been automatic legal guardians, now may possibly be guardians if they have cohabited with the mother of the child for a certain period of time. So look, what I'd ask you to do is, if you're faced with some situation whereby there's a dispute as to whether or not father is a legal guardian, then come to us and look for advice in terms of how best to deal with that. But just to know that it's always the mother who is the legal guardian, and if the parents are unmarried, it's more complex in that it's not automatic unless they have been cohabiting for a specific period of time. So that's to be borne in mind. Obviously, it's only when there's a dispute between the parents that it causes an issue for the school. I'm sure, well, I won't say 90%, that's probably too high, but for the most part, things can be agreed between the parents. But where there's a dispute in any aspect of it, and custody and access, either parent can apply to the court to determine those arrangements. Okay, so if there is a court order that's relevant to the school, then the school should be provided with a copy of that court order. A non-guardian parent and other family members can apply for custody and access rights as well. So that's open to them to apply to the court. So just to be conscious of that, and to be also aware of the fact that a guardian deprived of custody does not lose his or her rights as guardian. So to bear that in mind too when dealing with parents, just to understand the importance of the guardianship status and what that means, and to have some insight in terms of what happens in circumstances where there's a dispute. All too frequently, parents who are in disagreement try and bring the school into the middle of it. It's almost like a battleground where they try and fight out various issues. But for the most part, those issues belong in the family law court, and that's where those disputes should properly be resolved, if at all possible.
Edel, thanks for doing a whistle-top tour of what is a very in-depth and complex area. So well done on that. Paul, I'm going to cross over to you here to do data protection in one slide, but access to records, another biggie. I mean, since GDPR, the inception of it, we do a huge amount of work in the office in relation to that. So with that in mind, Paul, could you just give us a summary of where you see things as being at?
Absolutely, David. Yeah, I think there isn't a week goes by now that we don't have some data access requesting from a school that we have to deal with, and that includes during the summer break very often. So what I would say is, look, it is there. It is reasonable to comply and deal with data access requests made by a guardian on behalf of a student, and Edel has outlined who that guardian might be. I would add to that and say it's also vital that when you get a data access request that you act on it swiftly and promptly, because the one thing that you're up against in a hard way in those circumstances is time. But what the Data Protection Commission has started talking about recently and has engaged in a consultation process on is the data rights of children in and of themselves. And it has always been the case that children have their own data rights and always have had. There is a minimum age in terms of kind of data consent that was set down. GDPR allowed it to be as low as 13. It was set at 16 by our own legislation here in Ireland. But what the Data Protection Commission has said is that, look, if a child is of an age and a level of maturity where it is reasonable for them to be consulted in relation to their own data rights and they can make an informed decision about them, well, then you should consult with them. So that is, and we've had that, and I think Ian has had a case that where there was a junior cert student where an estranged father, separated father, asked for the junior cert results, and the student was consulted in relation to that because of their age and maturity, and the student said, no, I don't want my father to have those results, and that was the course that was taken. So it's just to bear in mind that it's not always just a straightforward, you get it, you answer it. There are other factors to take into account. And then as Edel has said, where you have a non-guardian parent involved, then you have a couple of extra steps to seek consent from the guardian and potentially then consult with the student as well.
Thanks for that, Paul. And finally, Paul, you're going to deal with, just briefly, with social media and the fallout of that. And maybe this is a good time of the year to just have a conversation with staff about that. So over to you, Paul. Absolutely. Social media in one slide, it could definitely be a webinar on its own, if not a couple of them. It is part of our lives. There's no getting away from it. Not only does everybody individually have their own social media accounts, but now most schools have a variety of social media accounts: Facebook, Twitter, Instagram, the whole lot. I think in both cases, both for the school's own accounts and for the people, students and staff within the school, it's vital that you have social media policy that makes it very clear to everybody what is allowed and what is not allowed. And then, as we said earlier on in the webinar, when you have your policy, it's vital that you know what it says and that you abide by it. And there are a lot of issues that come in under the social media kind of umbrella. You have data protection issues in relation to, for example, tweeting or putting up on Instagram pictures of children within the school and whether that is okay with their parents. You have, you can have other issues related to data protection. You can have issues in relation to cyberbullying and the issue of when that happens outside of hours, after school, between members of a class. How is that dealt with? So it is vital, I think, to have a proper policy in place in relation to that. And it's vital to take advice in relation to it because it is a very difficult and a very emotional and a very consequential part of young people's lives now. And we have to be aware of that. And I think, it's important that teachers and SNAs and members of staff, as well as principals, are aware and, understand the language and the context of social media amongst the students that they're involved with. I think it's important as well to differentiate between personal and school accounts for staff. I think if you have a personal account as a teacher or as an SNA, as a member of a school community, I think it's important that you designate that's your personal account and you're not speaking on behalf of the school. I think that's important both for yourself and for the school.
And I think, it would be important then that where the school has its own account, that's managed in terms of who can contribute to that and who can post on behalf of the school as well. And one final point, something that we have had come up on a couple of occasions within the recent past, is where you have complaints about the school that are being put forward through social media without any direct engagement with the school, where they're just coming on social media and making a complaint about something that happened during their time at the school. Usually this is alumni, past pupils. And in some cases, and I've had one or two instances of this where I've advised on, where it's allegations of historic sexual abuse within the school is being raised on social media. So look, that's a very difficult circumstances in the best of times, never mind having to do it through social media. So I think be very careful, as it says on the slide. I think you need to take advice in relation to that. You need to consider, how do we engage? Do we engage at all? What do we do in relation to it? So it's just something to be aware of. It's something that we're seeing happening. So, again, it's something that you can incorporate within your social media policy, and something that you should be considering, and that everyone should be alive to as you move through the school year.
Paul, on that cautionary note, thanks for pulling that piece on social media together. And now I'm going to hand back to Ian to do the wrap up, as it were. Thanks. Over to you, Ian. Ian has to unmute.
Thanks, David. So I'm not going to dwell just on these. You'll see the takeaways there. These are the things we've covered. So hopefully you have found some of the content of today's webinar helpful, and more particularly, so hopefully you will have found some of the content as suitable for perhaps sharing with your staff. You're going to get a recording of today's webinar if you registered for it, and I would please encourage you to fill out the sort of feedback invitation, because we find this really helpful. It keeps us focused, and indeed today's webinar and the focus on staff came out of a lot of feedback we have got. Other than that, and just those takeaways, I would just like to say thank you on behalf of Edel, David, Paul and myself, and the wider education team for joining, and to wish you all a good year ahead and good luck more immediately with the school opening. Thank you.